This is a joint work with Francesco Toguanto and Jiachuan Yao, both of them are here. So the title is Trust and Contracts, Empirical Evidence. So here we all know that in the contract literature, so there's always complete and incomplete contracts, and the extent of contract completeness affects incentive. Would affect a lot of economic outcomes. For example, economic incentive of firms, financial institutions, and financial activities. So for completed contracts, the benefit is that these contracts can restrict the scope for moral hazards, can reduce costly access to courts, and it can avoid delays in economic activities. But on the other hand, there's also incomplete contracts because it always gives the two parties some option value for flexibility. It also might be only possible outcome if the two contracting parties have boundary rationality. So ex ante, we cannot describe all the future states. The purpose of our paper is to explore the role of trust among contracting parties on the contract completeness. So here, first I want to clarify that our paper is a pure empirical paper, and we don't find any in the theoretical literature that theory works link trust with contracting practices. So here, so the first thing that issue of lack of theory is that we have a very, very broad definition of trust. So here's our definition of trust. If I trust other people, then I believe that the counterparty will behave fairly in negotiations in negotiations, especially if the other party has private information. He or she will behave fairly if unplanned state contingencies arise. So this is our very broad definition, which borrowed from Oliver Williamson. So obviously, this trust is highly linked to the beliefs. It affects how costly negotiation. The costly negotiation depends on these beliefs about likelihood of future contingencies, and also about your belief if other party might exploit her private information unfairly at the negotiation, or the other party might acquire the information through relationship and exploit it later. So this is our very broad definition of trust. And the second issue about lack of theory is that we actually don't have we don't have a specific model to bring to the data. So we derive our hypothesis based on very general assumptions. And the first hypothesis that the lower trust might increase contract completeness, because here we simply assume the two contracting parties have exactly the same information set. Obviously, two contracting parties have boundary rationality and have limited cognitive abilities, so they cannot plan on all the future contingencies. But for the contingencies they can plan on, the two parties have the exact same information set. So what happens if I don't trust the counterparty? So I might increase my expected costs of future unplanned contingencies, because I believe that other parties might behave unfairly to take advantage of his or her information exposed. So I would like to pay whatever costs to write a completed contracts. So this is hypothesis one. But on the other hand, a drop in trust might also reduce contract completeness. So the reason is that if we introduce information asymmetry upon contracting, let's say one principal and an agent, usually the agent has private information to begin with. So the principal might don't trust any clauses proposed by the agent, because whatever clauses proposed the agent, the principal will think that agent might exploit her private information to take out the surplus on the table. So the principal would like to leave these clauses open. The principal would like to leave the contracts incomplete until some time the principal acquires private information about the agent. So the two parties can renegotiate the contracts by adding those clauses. So my other question is, what the principal do before he acquires private information from agents? Usually, they allocate control rights. So think about the data contracts. So one sterilized effect in the data contracting literature is that usually the lender does not have enough information about the borrower. So when upon contracting, data covenants, which are used to allocate control rights, are extremely tight when the two parties sign a contract. But over time, so the well-documented phenomenon is that these covenants are relaxed over time through renegotiation, because the lenders acquire enough information about the agents. So the relax of these covenants means that some control rights are allocated to the borrower. So these are our two, competing hypotheses. Essentially, we don't know which one is right. So we're going to bring the data. We're going to bring this hypothesis into data. So the two, challenges to test our hypothesis. The first challenge is that we need a reliable measure of contract completeness for homogeneous comparable sets of contracts. So that, any change of these clauses could measure, the change of contract completeness. And the second is that because contract completeness and the trust are endogenously determined. So trust might affect the contract completeness, and contract in practice might also affect the trust. So we need an exogenous variation in the extent of trust among parties. So these two hurdles we have to clarify can be overcome in the, in the lab experiments. But, we are going to test this hypothesis in a high-stake contracting environment when the choices are made by the expert decision makers here. So in this paper, we have actually two goals. And the first goal is that we measure contract completeness for homogeneous comparable contracts. So we construct a large sample principal agent contracts between US corporations and the consultants, from firms' SEC filings. So we measure contract completeness with textual analysis. The first method is that we simply use a structure analysis to count the, the number of words. And, if the contract has more unique words, then we think the contract is more complete. And the second analysis is topical analysis. Basically, we count the number of topics. We take into account the connection among the words in a contract. So I'm going to tell details later on. So we think the consulting contracts is a desirable application because these contracts are written by very sophisticated lawyers on behalf of two very sophisticated contracting parties. So one party is public firm, and here we simply assume the manager acts on behalf of all the shareholders. So the one contracting party, the principal side is manager, and the agent side is professional consultants. So, and also the contracting, the formats are very standardized. It's not like newspapers or any letters to shareholders or free narrative body languages. So these contracts are very standardized in terms of formats. Later I will show you a contract. So any change of these clauses should not be random. The second goal of paper is that we exploit quasi, exogenous variation extent of trust among contract parties. Here we use Arthur Andersen, Aaron scandal and demise of the consultant Arthur Andersen as a shock to the trust between shareholders and the consultants. Actually, the first paper, January 1, showed that, after break of this scandal, there's a drop in the trust among shareholders. And we exploit the variation exposure of the local shareholders across states over time. And we also, test, do the placeable test to exclude time trends and also US-wide regulatory change, especially the SOX, which is very important. So these two figures show the main results of the paper. So in the first figure, left-hand side figure, it's the survey results of the the college-educated students. Basically, the Gallup survey asked them, do you still trust a big business? And we see that after the Iran scandal, there's big drop of this trust. On the right-hand side, we have the consulting contracts, and we have a measure of contract completeness. Basically, it's a number of topics, but later I will tell you, how we measure contract completeness. We see after Arthur Andersen, there's huge jump in terms of contract completeness. So these are contracts between the company and external consultants. So external consultants, these are independent consultants not affiliated with the firm. But one first question is that maybe this macroeconomic shock affect many things. Many unobservables might affect the results. So here is a difference in design. So we actually take the advantage of the cross-states variation in terms of Arthur Andersen share, which is measured by the number of Arthur Andersen clients as a fraction of total public firm in the States as the second source difference. We find the effects especially strong in US states with a high share of Arthur Andersen clients after 2002 Iran scandal. We did a lot of placeable tests. For example, we look at the contract in practice between firm and the internal consultants. These internal consultants already had a share in the company or already had a previous working relationship with the company, and we did not find any change in this contract completeness after the SOX. And also we look at the shared clients of other big five consultants, other big five consulting companies. We did not find any effects of other big five consultants' shares on the effects of the effects of trust and contract completeness. And now you might argue that maybe our results capture the contract complexity instead of the completeness. So here, what do we mean by complexity is that if it's very difficult to write the nature of the contract, to write the nature of the transactions ex ante, then we say, okay, the contract becomes more complex. So here, if we say that complexity only increases completeness if additional stated contingencies are added into the contract. So here we look at two new clauses, individual clauses. The first one is equity incentives. So after Arthur Anderson, probably the agent, the consultant don't trust the public company because they think the public companies will manipulate performance, and the managers will not have incentive to maximize firm value. So the consultants might less likely to accept equity incentives. Here it's indeed what we find. Obviously, this less equity incentive clauses means that the contract will be more complete, but less complex. And the second clauses we use is non-compete agreements at the contract level. So after the talks, maybe the principal, the public company does not trust the consultants. So they might use non-compete agreements to restrict the consultant's action. Here, the non-compete agreements increase contract completeness, but does not increase contract complexity. So this is our summary of the main results. This is our talk plan. So first, we're going to talk about how to measure contract completeness. And the second, we're going to talk about how the valuation trust between shareholders and consultants, how we verify this in our data. And then we talk about baseline results. Basically, it's a relation between the trust and the contract completeness. And we do a lot of placeable tests and robustness. And the last part, we want to distinguish between complexity and the contract completeness. So we analyze specific clauses. So the two clauses I mentioned, equity incentive and non-compete agreement. So this is our plan of talk. So, okay, so here's how we measure the contract completeness. We have two steps. The first step, we actually download all the consulting agreements. That's a sample of homogeneous and comparable principal agent contracts. And we use textual analysis to measure completeness. The first approach is structure analysis. Basically, we count the number of unique words and the sentences of the contract. And the second approach is topical analysis, and we define and measure topics. So we think the textual analysis is especially suited to analyze the consulting contracts in our setting. The words in these consulting contracts are well-defined legal meanings. So they barely change over time. It's different from newspapers or and a journalist, economist writings that these writing styles are responding to changing political environment, political ideologies, and investor sentiments. And the second, the contract structure is highly standardized. So later on, we show you the contract. The formats and is very, very standardized. So it's different from letters to shareholders or any free body narratives by firms. Usually if you check these formats, the formats of letter to shareholders vary a lot across companies. We accept download the material contracts filed with the SEC from 1991 to 2015, which include the U.S. public firms and also firms with issue the public debt. And two types of filings, Exhibit 10K exhibit and 10Q, and also the 8K. For the 8K, basically, it asks a company to report these material events within 4 business days. And we have different timing information, especially, firm can choose to disclose the contract through either 8K or 10K or 10Q, but this, there's larger, accounting literature talking about this. Here, this is not our scope of our paper, but later you might worry that the SOX might affect the firm's choice of the 8K versus 10K. And later I show you that after SOX, indeed, the contract, the disclosure practice does not change across firms. Also, we identify consulting agreements by searching for the keywords, consultants, the keywords, and we exclude amendments, which is contract renegotiations. And also we exclude duplicates and also, other contracts with missing information. So here's one example of the contracts. So this is a contract signed between the public company, is the First American Corporation, which is a California corporation, and external consultant. So this consultant is an independent consultant. Name is Frank Macomb. So you see the formats. So the first item is a service, and second item, describes what the independent consultant should do and what he is. And then the third format talks about, third item talks about compensation. So basically there's a combination of equity versus cash compensation. And then the contract talks a lot about the performance requirements and non-compete clauses and other things about the confidential information, and whether if some disputes happens, what is the states the two parties choose, and also whether or not the two parties will choose to go to the arbitration, something like that. So now the question is, how do we turn from words into numbers? So this contract is one data point, our sample. So the first approach is we use a structural analysis. So consider the following sentence from the contract. If the two arbitrators are unable to agree as to identify of such third arbitrator, so each of the consultants and the company may request that the American Arbitration Association, AAA, select arbitrator, which shall then be selected by the AAA. So we eliminate the functional stop words and get a list of working words. Here the arbitrators and neighbor agree, these words are working words, and then we keep unique words. So unique words are these arbitrators, a neighbor agree, blah, blah, blah. Then we count the number of unique words, 13 unique words. So I think this sentence has 13 unique words. So this actually measures the length of this sentence. We exclude, here obviously the advantage is that, this contract is highly standardized. So there's no issue like more or less verbal texts, synonyms, ambiguity. But, the disadvantage of using this approach is that we don't exploit all the topical connections among these words. Because obviously, many similar words actually connect to each other. If we think about the state of contingency, probably many connected words only measure one state contingency. So the second approach we use is that we use a latent Dirichlet allocation procedure. We borrow from prior literatures. We have, it has two steps. Basically, we call it LDA, mimics the human being on how to write a contract. The LDA assumes each contract has its own topic distribution. Basically, topic is measured by a connection of the words, and each topic has its own word distribution. So the LDA randomly draw topic from the contract and also randomly draw word from the topic. So the LDA basically draw every word from the contract to write a contract. Then we set the parameters immediately. Eventually, we have until we get the best parameters. So that's the LDA analysis. And so first we identify the topics, groups of words consistently mentioned close to each other. And the second step, we assign each sentence of the contract, our sample, to a specific topic. So the number of topics in a contract is our measure of contract completeness. So here's what LDA does. So the first step, it clusters words into n topics based on how often they appear close to each other. It's similar as a principal component analysis. And for each word, it assigns probability belonging to the topic based on how often it appears close to the other words in the topic. And each word actually has different topics because each word has different probabilities of belonging to other topics. But from text to topic matrix, we have a list of words with attached probability of belonging. If the word has a higher size, it means the word has higher probability of belonging to this topic. So this is one example. This is one topic identified by our LDA. It's called the resolution of controversies. We label the topic as resolution of controversies. We see the arbitration. So this arbitration word is very large because this arbitration very frequently appears to such a topic. So there are also other words like dispute, arbitrators, law, jurisdiction, and these large size words are very frequently appearing to the topic. And sometimes there's some small words that are unrelated, and also some other topics. But these words they really have very small size because the probability of belonging to this topic is very, very low. And here's a second example, and the second topic is called proprietary information and the trade secrets. So in this topic, we see the information, the size is very large because information very frequently appears in this topic. And then we also see property, termination, and the inventions. So in this, most of the words consistent with definition of trade secrets. So this is our second example. But also we see some, very small words with a very small probability of belonging to this topic. Our second step is to assign each sentence of the working sample contracts to a topic. So this is one example. For example, look at this sentence. Still the same sentence as before. If the two arbitrators are unable to agree as to identify such third arbitrator, and the two parties might go to the American Arbitration Association to select a third arbitrator. So this sentence belongs to a unique topic, belongs to the topic which is called the resolution of controversies. And here's another example. We have another sentence. If the schedule sets forth a complete and accurate list of each license and license agreement by date, termination parties, and for each patent, the patent application, invention, trade secrets, rights to know-how, process, computer programming, or use technology, held or employed by the seller, and blah blah blah. So this sentence belongs to the topic of the proprietary information. So for every sentence of the contract, we assign a unique topic. Albeit every word has, is belonging to different topics with different probabilities. Okay, so now I've talked about how we measure the contract completeness. So let me talk about how, first, the second thing is how we verify, the variation of trust between shareholders and consultants. So we exploit, Enron scandal and demise of Arthur Andersen. So Enron Corporation is one of the largest financial fraud scandals. And most of us know the timeline here. So in 2001 March, article questions about Enron's financial performance, and later on the Enron's restated financial statements. And in the 2001 November 13, the Enron files for bankruptcy. And on the Arthur Andersen's largest is a consulting and accounting company for the Enron. So it's one of the big five. And it does both auditing and consulting. And the crucial thing that why Arthur Andersen, has the incentive to help the Enron to manipulate performance, because Arthur Andersen also, has a very large, auditing, a very large share of consulting services for this Enron Corporation. So, here's a timeline. Eventually, Enron dismissed Arthur Andersen, but Arthur Andersen convicted for obstruction of justice, and the U.S. Supreme Court overturns convictions. But Arthur Andersen dissolved. So today, part of our operation closed. Part of it goes to the Ernst Young, and part of it goes to other consulting companies. So so this is a drop in trust. The drop in trust in big business practices, and we basically replicate the results in the January 1 paper. And in January 1 paper, so they find that households are shareholders of public companies, and households usually hold the shares in the local states. And once the scandal breaks out, households don't trust the company, so they sell the shares because they don't trust the management and don't trust the business counterparties. Here we actually look at what happens if households, some shareholders don't sell their shares, they still hold the shares of the company, means that they still trust the practice of management, but they might not trust the business counterparties. They might not trust the outside consultants. But you might argue that this is maybe captured by time trend, or it's driven by other shocks in 2002. And then we exploit the cross-states variation in terms of Arthur Andersen share before the Enron scandal. So this is we look at the Arthur Andersen clients in 2002 across states. So each states we have a number of public firms. Some public firms with Arthur Andersen clients in 2002, and many are not. So for each state, we calculate the share of Arthur Andersen clients in 2000 as a second source of the variation. The first, we basically replicate the results by January 1. We focus our sample on the college-educated students. So this is from the Gallup survey data. So this is so sample unit is about individuals, individual respondent. The sample period is, I think, is from 1990 to the 2015, something like that. And the left-hand side variable is a high trust. So the question is, do you still trust the big business? And if you answer yes, then it's 1. Answer no, it's 0. And on the right-hand side variable, so we have the post dummy, basically it's dummy 1 after 2002. And we also have the second variation, which is a dummy if the Arthur Andersen share is above the 25th percentile of the sample distribution in the United States. And we see that, first after 2002, the trust, drops despite whether the states is in high Arthur Andersen, low Arthur Andersen. But in states with high Arthur Andersen share, we see an additional big drop in terms of trust. And our results are very robust, by including the year fixed effect and the state fixed effect. So basically, this table basically replicates the generative one. So we confirm that indeed, in the states of high Arthur Andersen share, we see a big drop in the trust in big business. Now you may ask a question, probably our results captures time varying trend in terms of consulting services. So we do our first placeable test. We redefine our treatment. There's a placeable test. So if the Ernst & Young share is above 25 percentile in the States, or if Deloitte's share is above 25% of the States, if KPMG or PwC's the shares above 25 percentile of the States. And we do exactly the same specification, except that we use the top 25 percentile is based on the shares of other big 5 consulting companies. We see that actually we did not find any results. Basically, trust did not drop in states where the other big 5 consulting companies have high, consulting share. So it means that our results are not driven by time, the time varying industry conditions of the consulting industry. And the second placeable test is that probably might ask, well, so after Arthur Andersen, maybe the 2 contracting parties, the principal agent, don't trust the court, don't trust the judicial system, or they might don't trust, other small businesses. They might don't trust the banks. They might trust many things. So here is our second test. Now we replace the left-hand side variable, the trust, with the survey results about question, do you still trust the small business? Do you still trust the judicial system? Or do you still trust banks? And on right-hand side variable is, the top 25 percentile is whether or not in the States, Arthur Andersen client share is above top 25 percentile distribution. So we see that in these states, people still trust the small business. People still trust the judicial system. People still trust the banks. So indeed, so we verified that. We also did a lot of other, left-hand side variables. So indeed, verified the Arthur Andersen shock caused a drop in trust in big business state, in big business state practices in states with high Arthur Andersen share. So this is our first set of results. Because here, why I want to verify this, because these consulting agreements are signed between public companies. So these are big business and consultants. Okay, and now we talk about baseline results. So this is our baseline specification. On left-hand side is contract completeness measure. Basically, it's a number of topics in the contract, from our LDA analysis. And on right-hand side variable, we have obviously this account, the variable is a count number, so with negative binomial regressions. On right-hand side variable, we have the post 2002, and treated this dummy 1 if a state is above top 25 percentile in terms of the share of Arthur Andersen clients as of 2002. We don't use IV. Probably you will ask why we don't simply instrument the trust by using Arthur Andersen share, because here we see that the trust does not affect the contract completeness in a continuous measure. So we only identify the states in which trust drops substantially lower, then we identify the effect of trust on contract completeness. And we also include X is a bunch of control variables like a reporting form dummy, whether or not the firm chooses 8K or 10K, and the company consultant dummy, whether consultant is company or individual consultant. And the arbitration dummy, whether 2 parties choose to go to the arbitrations or not. And average previous year stock return, and average previous year stock return volatility, and also the state level economic variables, the GDP. And we have state fixed effect, year fixed effect, and the industry fixed effect. Here, unfortunately, we don't have the we don't have sorry, my headphone does not work. Can you hear me? Okay. Okay.
Yes, yes. We can.
Okay. So so we don't have firm fixed effects simply because we don't have within firm variation in these contracts. This is our main results. So so the left-hand side was contract completeness. We see that after 2002, basically in the states with high Arthur Anderson share, so there's increase in this contract completeness. So the magnitude is about a 2.31 more topics. It's about 10% of the average. So now you might have a question. So what exactly are these newly added clauses? So what are these newly added clauses? So we look at data. So basically after 2002, in states with high Arthur Anderson share, so the newly added clauses are confidential trade secrets, indemnification and liabilities, and the jurisdiction and arbitrations. So we think these newly added clauses after 2002 in these treated states are very meaningful. Basically, they capture the capture story that if the two parties don't trust each other, they might add these new clauses. And we did a bunch of robustness tests. For example, we use a continuous share, we use weighted least regressions, we use alternative optimal number for topics. Here we simply assume that 200 topics is the optimal number, but now we replace this 100, 300. We actually also have alternative measure of completeness. For example, with the total number, with the total number of words and total number of unique words and total number of unique sentences. We need to find a very high correlation between the number of unique words and number of unique sentences with our measure of contract completeness from the topic model. And we also did a falsification test. The first one, look at whether or not the trust would affect the contract in practice between the insiders and the companies. We did not find any results because insiders, still trust the company. We also did, another test by looking at the share of other big five across states. And one big question is that would our results capture the effect of the Sarbanes-Oxley? And obviously, Sarbanes-Oxley changed the firm's reporting practices, but we argue that this is a nationwide shock because Sarbanes-Oxley applied homogeneous to all the companies in all the United States, in all the states homogeneously. And we find actually in terms of reporting practices, companies still report a similar number of contracts disclosed over time, and we still have the similar pool of firms, consultants over time. I'm talking about results. Okay, so this is the first falsification test. In the first column, we replace the left-hand side of the variable with a completeness measure from the insider consultants. So these consultants have, previous working relationship with the company, for example, CEOs and directors, or high-level employees like engineers. When they step down, the companies also want to sign the consulting agreements with them. So these insiders hold the shares in the company, so they trust the management. So these insiders also have business connections with the company. So we did not see that the contract becomes more complete in the states with high Arthur Anderson share during the post-2002. And the second to fifth column, we basically replace the treated variable with the dummy variable equals to 1 if the other big five consulting company market share is above 25%. So again, we did not find any results. Basically, our results are not driven by the time varying trend in terms of industry condition, in terms of conditions of the consulting industry. Here's the number of disclosed contracts per firm over time. So you might worry that the SOX might affect the company's reporting practices, but we see that number of contracts disclosed per firm stays very stable over time. There's not a big change in companies' reporting practices. We also look at other company characteristics. For example, the share of high-tech non-profit companies, the share of outside consultants, and share of individual contract consultants. We did not see any change. We're currently also working on to identify the consultants type. So what kind of exact consulting services these consultants provide? Probably we also want to do similar things to look at whether or not the consulting service type will be changing after 2002. Okay, So I think I'm running out of time. So the last part is that we want to distinguish between completeness and complexity. So you might ask, probably our results were driven by complexity. So we analyzed two specific clauses. So the first clauses is, so the first thing I want to show you that, these are the type of clauses that are increased, we find increased after 2002. For example, confidentiality of trade secrets increased by 10%. Indemnification of liabilities increased by 8%. Rights and obligation of both parties increased by almost 4%. And just jurisdiction arbitrations increased by 6%. Contingency related to the contract termination 5%. And the rights and benefits agent 4%. You see, these clauses actually, they increase contract completeness, but that's not necessarily increase complexity. But they don't make the contract more complex. So here we think that complexity means that the company, if it's very difficult for the company to describe the nature of the transactions, describe the nature of the future states, then we say, the contract environment becomes more complex. But we see that complexity only increases completeness if we see a new additional state contingencies clauses being added into the contract. So then we analyze two specific clauses. The first one is principal versus agents friendly clauses. The first one is non-compete clauses. Basically, if the principal does not trust the agent, the company might increase non-compete clauses because if the consultants later on sell the company's private information to the competitors. And we argue that the non-compete clauses increases contract completeness, but does not increase complexity. So here's our regression results. And here we also argue that companies would only increase these non-compete clauses if in the states where non-compete is more enforceable. So here we split our sample based on whether or not in the states non-compete law is more enforceable or not. We find indeed in the states where the non-compete law is more enforceable, we find during the post period in the treated states, there's substantial increase of these non-compete clauses. We call this principal-friendly agreements because it benefits a public company. And obviously, these non-compete clauses increase contract completeness. And the second clause is agent-friendly clauses. Because here the trust is two-sided predictions. The principal does not trust the agent. Also, the agent does not trust the principal. So after Arthur Andersen, scandal, the consultants do not want to accept equity incentives because the companies are manipulating, performance, and the consultant does not believe the company manager would maximize firm value. So such a lower trust might prevent the consultants from accept equity incentive. So we look at left-hand side variables whether or not stock option clauses or the equity clauses are added into the contract. And the right-hand side variable have the same specification. We see, in after Arthur Andersen scandal, in the treated states, in states with high Arthur Andersen share, there's a big drop in terms of these equity incentive clauses being added to a contract. So the consultants do not accept stock options, consultants do not accept equity incentives. Here we think it's a demand channel, it's not a supply channel, because at the company side, the company always wants to shift the risk to the consultants. The company always wants to give ground stock options equity to the consultants. And also, if you want to keep the consultants tight-lipped, specify the vesting period, and consultants will not tell the private information to the counterparties. So here we think it's a demand channel that drive our results. Basically, consultants do not want to accept this equity-based incentive. Okay, I don't know how many time I have. I'm running out of time. So basically we studied how does trust among parties affect the contract completeness. And basically we find the lower trust increase contract completeness. Thanks very much. I think I'm running out of time.